Picture this. It's 11 p.m. and you're sitting at your desk staring at a freight invoice that seems to have completely exploded. The total has jumped by another 30 to 50% just this month. You're looking at endless lines of escalating fuel surcharges, skyrocketing fertilizer costs, and emergency fees. Meanwhile, the headlines on your phone simply read Hormuz crisis, basically treating the whole situation as just another vague geopolitical chess match. But as you look at those numbers aggressively eating into your margins, the real question keeping you awake is much simpler and a whole lot sharper. And this isn't just an isolated nightmare happening at your desk. According to an incredibly blunt press encounter on August 24, 2026, by the UN Secretary General, global container rates were reported to be a staggering 84% higher year-on-year. 84%. And it's not just shipping containers. Fertilizer and other critical input costs have risen sharply right alongside them, causing weaker harvests, inflation, and severe hardship. And that hardship is falling heaviest on the world's most vulnerable. Okay, let's dive into this. We are going to solve the core legal mystery behind that exploding invoice. Does international law actually allow a coastal state to unilaterally close, toll, or enforce prior authorization on commercial ships moving through an international strait? Or is what we're seeing a clear breach of international rules that the global system is currently failing to enforce? Today's explainer cuts right through the geopolitical noise to look at the exact legal mechanics at play. Here is our roadmap for today. First, the anatomy of the choke point. Second, the transit passage rule. Third, customary law and exceptions. And finally, a practical action plan for shippers dealing with these costs right now. Section 1. Anatomy of the choke point. Let's zoom out for a second and look at the macro geography to understand exactly why this specific stretch of water is causing such intense global economic pain. The sheer volume of trade relying on this single geographic bottleneck is immense. We're talking roughly 1/5 of the entire world's oil passing right through the Strait of Hormuz. And it's not just oil. Significant volumes of liquefied natural gas, petrochemicals, and those critical fertilizers we mentioned earlier rely entirely on this one route. It is literally a systemic failure point for global trade. Now, what's really interesting about this is the sheer physical constraint of the geography. The Strait of Hormuz is incredibly narrow, only about 21 to 24 nautical miles wide at its narrowest point. Now, in international maritime law, a coastal state claims a 12 nautical mile territorial sea. Because the strait is so tight, the overlapping territorial seas of Iran and Oman completely swallow the entire waterway. There is absolutely no open high seas corridor in the middle for ships to freely cruise through. You are always inside someone's territorial waters. And that incredibly tight geography has made it highly susceptible to disruption. Since early 2026, the strait has seen a series of severe complications. We're talking mining incidents, unilateral route restrictions, explicit threats of fees or mandatory services charges, reduced daily transits, and sustained incredibly high war risk surcharges. Objectively speaking, these physical barriers and route restrictions are the direct mechanism driving the global inflation and weakened harvests that the UN Secretary General highlighted. It's exactly why your freight bills are soaring. Section 2. The Transit Passage Rule. So, the big question, do these coastal states actually have the legal right to impose these restrictions in their territorial waters? Let's look at the governing legal framework to find out. The mechanism here is the United Nations Convention on the Law of the Sea, or UNCLOS, specifically Part 3, which covers straits used for international navigation. The plain English principle here is that freedom of navigation isn't just some vague, lofty ideal. It is a hard, binding legal rule. Under Articles 37 to 44, all ships and aircraft enjoy the strict right of transit passage. This guarantees the continuous and expeditious transit of the strait between one part of the high seas or exclusive economic zone and another. The law is incredibly clear on this. Coastal states shall not hamper and shall not suspend this transit passage. Now, we need to make a really clear distinction here, because this is where a lot of the confusion happens. Ordinary innocent passage, which applies to standard territorial waters, actually can be temporarily suspended by a coastal state for security reasons, but transit passage through an international strait cannot be suspended. Ever. Ships do not need to ask for permission or prior authorization from either state merely to sail through. And this brilliantly illustrates a vital difference in global shipping. Man-made canals like the Suez or the Panama Canal are not natural straits under this UN-close regime. Their operators can completely, legally charge tolls for passage, but the Strait of Hormuz is a natural international strait. Under the transit passage rule, general tolls simply for the privilege of passage or the selective denial of vessels are legally invalid. Section 3. Customary law and exceptions. Okay, but there is an obvious catch here that we absolutely have to address. Neither Iran nor the United States have actually ratified UN clause. So how does this even apply? Well, the transit passage rules are widely regarded as customary international law, meaning they are universally binding, regardless of whether a specific country signed the treaty. Let's look at how this builds a binding legal reality, even for non-parties. This foundation actually dates back to the 1949 International Court of Justice ruling in the Corfu Channel case, which firmly established the absolute right of passage through international straits without prior authorization. Add to that decades of state practice, like the 1968 Iran-Oman traffic separation scheme, which was approved via the International Maritime Organization and safely governed passage for decades. Oman, by the way, is a party to UN clause. This massive weight of historical practice proves these rights are firmly embedded as customary international law. Of course, there are important nuances to this. Coastal states absolutely retain sovereignty to regulate safety, pollution, and traffic schemes, provided they meet international standards and act in a non-discriminatory way. Furthermore, fees are technically allowed, but only for specific, tangible services actually rendered to a ship, like pilotage. You cannot charge a blanket toll just for sailing by. Finally, even during armed conflict, where the law of naval warfare overlaps, neutral commercial shipping retains its protections, even if real-world military necessity creates friction. So the crucial point is this. The vulnerability causing your freight bills to spike isn't a flaw in the legal framework itself. The law is rock solid. The problem is practical enforcement. A legal framework without an effective collective response can eventually be eroded by unilateral facts created on the water. Section 4. Practical steps for shippers. Which brings us right back to your desk. Away from the high courts and international treaties, what should a stressed commercial actor actually do right now? Well, here's your practical action plan, whether you are a charterer, a ship owner, an insurer, or an importer. Step 1, document absolutely every extra cost, fee, and delay specifically against this legal baseline we just covered. Step 2, price your war risk and Cape of Good Hope diversions in your financial models as temporary disruptions, not as structural, permanent changes to global trade routes. Step 3, keep a close watch on IMO and UN statements for any formal, state-backed challenges to discriminatory measures in the Strait. And finally, Step 4, if you're presented with a blanket service fee regime applied to all transit traffic, treat it as legally vulnerable, not as the new normal you just have to accept. Because when you strip away all the noise, this is the undeniable, objective bottom line of this explainer. Transit passage through international straits is a non-suspendable legal right. It is not a favor that a coastal state can revoke or monetize at will. When that foundational rule is allowed to fray, every single shipping container, every ton of fertilizer for our crops, and every fuel bill immediately becomes collateral damage. I want to leave you with a provocative thought today. We've established that the legal right to uninterrupted passage is undeniably clear. So what concrete collective enforcement steps, beyond just issuing statements, will it take to actually restore predictable transit and prevent this exact same pattern of extortion from happening at the next global choke point? Think on that. And if this explainer helped clarify the true legal reality behind those soaring freight bills, share it with anyone in your network who still mistakenly thinks this massive disruption is purely a matter of geopolitics.